suppose A institutes a suit for recovery of possession. B contests the suit. B files the written statement. Issues are settled. Evidence is recorded. And then after the contest, the suit is decreed. When the suit is decreed, the defendant B files an appeal, while A as a decree holder files an execution petition. B does not succeed in getting the interim injunction in the appellate court, and the decree is not suspended by the appellate court. So the execution continues. In execution proceedings, the court issues warrant of possession. Then at the spot, possession is taken away from B. B is deprived of the possession on account of the decree which was under appeal, meaning thereby that by the act of the court he was deprived of the possession in the execution proceedings. When in the execution proceeding he was deprived of the possession, what happened? It happened that his appeal was accepted. The decree was set aside. Now B was deprived of the possession under the decree, and the decree was set aside. Then what should be done now? Should he file a separate suit for recovery of possession, or is there any other remedy available to him? What can he do? So there is a principle of restitution. That is an equitable principle. The court has delivered the possession to A. It was the court who did an act, and on account of the decree of the court, he was deprived of the possession. So the equity demands that the possession should be restored back. Now what is the procedure for that? That is the procedure of the restitution. The same court shall be taking actions for the restitution of the property. Principle of restitution is applicable or attributed when there is a applicant fulfills three conditions. There are three conditions which are to be fulfilled for the purpose of applying the doctrine of restitution. The restitution must be in the respect of the decree that was varied or reversed. If the decree is not reversed and the decree is not varied, then the doctrine of restitution shall not be applicable. It shall apply when the restitution is in respect of the decree which has been reversed or varied by the superior court. So when the decree is set aside, it means that there is no decree. Whatsoever was done in an unlawful manner. At that time that was lawful when the decree was passed. But when it came to the conclusion that the decree was not validly passed and that was set aside by the appellate court, then there did not exist any decree. So the person who suffered on account of the execution of the decree should be compensated in the form of restitution. The party applying for restitution must be entitled for the benefit under the reversing decree, meaning thereby that the person who deprived of the property on account of the execution of the decree is the person who is entitled to get back the property. No third person can seek the remedy of restitution. It is only the person from whom the possession was taken away. He is the person who is entitled to the restitution of the property. The relief must be consequential or on reversal, and the party should be entitled thereto. So it should not be against equity. the restitution should not be against equity. It means that it is an equitable principle. When there is an equitable principle, equity will be followed. So if the restitution is against the equitable principle, then the restitution shall not be ordered. So the restitution is ordered only when it is not against the principle of equity. So these three conditions are to be fulfilled for the purpose of restitution of the property. The doctrine of restitution does not confirm a new substantive right. It is not conferring a right on you, but it is giving you the right which you had already in existence, and an agreed party does not possess under the general law. The doctrine is applicable whenever the person is deprived of his right of possession, he shall be restituted. So because in this situation he has been deprived of, so he shall be entitled to the restitution. So that it does not confer any new right, but it recognizes your existing right. Principle of restitution is applicable whenever there is a person deprived of the possession from on account of the decree which was executed and later on the decree was set aside. Section 144 embodies the principle that nobody shall be prejudiced by the act of the court. It is a general principle that no one should be prejudiced by the act of the court. The foremost duty of the court is to take care that the act of court does no injury to the suitor. In the first time when the decree was executed, the decree was in existence. That was executed on account of the order of the court. So when it was executed on account of the order of the court, it was an act of the court. But when the appellate court said the decree is not valid, the decree is set aside, then the act of the court was to be compensated by the court itself. So the court shall order for the restitution. For this purpose, you may kindly see PLD 1999, Quetta, page 56. Object and rationale of Section 144 CPC was to place parties in same position as they occupied prior to decree, which had been reviewed by court of competent jurisdiction. Basic principle underlying right of restitution was that a wrong done to a party by act of court should be rectified. Word party used in section 144 was not only confined to parties to the suit, but it included assignees, transferees from decree holder, and applied to persons who had subsequently obtained interest therein. So this is the basic rationale and object of section 144, which has been explained in this authority. Another authority is 204 YLR, page 122. The scope of application under section 144 CPC is limited, and the doctrine of restitution implies that on reversal of a decree, the law imposes an obligation on the party to suit who received unjust benefit of the erroneous decree to make restitution to the other party of what he has lost. This obligation arises automatically on reversal and or modification of decree, and necessarily carries with it the right to restitution of all that has been done under the erroneous decree. The court is, in making restitution, are bound to restore the parties so far as they can be restored in the same position as they were at the time when court by its erroneous action had displaced them from provision of CPC governing application for restitution does not confer any new substantive right, but it merely regulates the power of court in that behalf. So both these authorities are relating to the restitution of the property. So the restitution is ordered in all those cases when the ingredients which I have already enumerated before you have been completed. So it is in fact an equitable principle that no one should be prejudiced by the act of the court. When the court is committing an act, once the decree was valid, it was executed, but when it came to the conclusion that the decree was not valid, but it was set aside or varied or reversed or modified, then the person who suffered any loss on account of the execution of the decree should be compensated, and when the possession has been taken away from him, the possession should be delivered back to him. So the restitution is ordered by the same court and no separate suit is competent.